Between February and June 2016, the Illinois State Historic Preservation Office conducted its historic review of the proposed Pullman Artspace Lofts project. The SHPO issued 2 clearance letters. These approval letters basically claimed the proposed new construction would have no adverse effect upon Pullman's historic resources or the Pullman National Historic Landmark District. In September 2017, the Department of Housing and Urban Development, HUD, determined that these reviews were not conducted, quote, in accordance with federal statute and as such are invalid, end quote. Consequently, HUD ordered a new historic review for the project. This presentation will introduce you to this review and explain how you can be a part of it. In Part 1, we'll look at 2 important environmental reviews required under federal law. In Part 2, we'll take a detailed look at the Section 106 review process. Then in Part 3, we'll tell you how you can become a participant in the review. The National Historic Preservation Act of 1966 requires the federal government to examine how its projects might affect historic properties and to take action to reduce harm to them. 3 years later, Congress passed the National Environmental Policy Act of 1969, or NEPA. It expanded environmental reviews and formally established environmental protection as a federal policy. The reviews these laws require make federal officials stop, look, and listen before making decisions that impact historic properties and the human environment. NEPA reviews examine how a project might impact the environment or community in a wide variety of ways. Impacts can be anything from noise, to parking, to pollution, to visual disturbance, as well as changes to a community's cultural fabric. These impacts are cataloged in long technical reports. If a project is found to have no significant impact, the reviewers issue a FONSI, a finding of no significant impact. The public gets to comment on the NEPA finding, but doesn't really participate during the review. By contrast, the review required by the National Historic Preservation Act is narrower in its scope than the NEPA review and allows more public participation. This review, known as a Section 106 review, requires the responsible federal agency to identify and resolve a project's, quote, adverse effects on historic properties, unquote. This is accomplished through consultation with governmental agencies, organizations, the public, and other interested parties. Today, for the most part, Section 106 reviews occur as an integral part of the broader NEPA review. When the National Historic Preservation Act was passed in 1966, it created the Advisory Council on Historic Preservation. The Council is an independent federal agency and is responsible to see that the Act's requirements are properly executed. The Council provides guidance and advice and generally oversees the operation of the Section 106 process. The Council also consults with and comments to agency officials on individual undertakings and programs that affect historic properties. Consultation with the public and qualified consulting parties is the cornerstone of the Section 106 process. Much more than a one-off public meeting or a chance for public comment, consultation during a Section 106 review, if done correctly, should lead to a binding agreement about how best to protect the integrity of the affected historic property or properties. A Section 106 review has 4 basic steps. Step 1, initiate the process. Step 2, identify historic resources. Step 3, assess if adverse effects. And Step 4, resolve adverse effects if needed. In Step 1, the federal agency initiates the Section 106 review once a federal undertaking has been established. If the project is an undertaking and has the potential to cause effects to historic properties, the federal agency then notifies the State Historic Preservation Office and begins to identify those who know stuff about the affected historic property. These people and organizations can ask to serve as consulting parties. The federal agency must also plan public involvement. In Step 2, the federal agency consults to identify an undertaking's area of potential effect, or APE. The federal agency must also consult to identify all National Register eligible historic resources located within the area of potential effect. An undertaking can have a direct, indirect, and cumulative effects on historic properties. In the case of the Pullman Artspace Lofts, multiple areas of potential effect should be defined. For example, the project will obviously have a direct effect on the site where it is to be built. However, the area from which the project can be seen or heard should also be included as an area of direct effect. Likewise, by fundamentally altering Beeman and Barrett's original plan for the model town, the project will also have an indirect effect on the integrity of the entire Pullman National Historic Landmark District, and by extension, the Pullman National Monument. And what about the cumulative effect of allowing more and more non-Beeman buildings on sites that were once part of the town of Pullman's original plan? Or what about the cumulative effect of the traffic from adjacent strip mall developments, planned industrial warehouses, and this project? Once the area of potential effects is established, the federal agency must make a good faith effort to identify all affected historic resources in the area and determine if they are eligible for listing on the National Register. The town of Pullman was declared a National Historic Landmark District in 1970 and a National Monument in 2015. Therefore, Pullman's historic resources should consist of anything surviving of the town of Pullman between 1880 and 1907, above or below ground, and the National Historic Landmark District itself. If these early stages of the review are done half-heartedly, the Section 106 review will be compromised and historic properties will be in jeopardy. After the area of potential effect is defined and the affected historic resources are identified, Step 3 requires the federal agency to assess whether or not a project will have an adverse effect on the historic resources. The criteria of adverse effect are used to determine whether an effect is adverse or not. An adverse effect is found when an undertaking may alter, directly or indirectly, any of the characteristics of a historic property that qualify the property for inclusion in the National Register in a manner that would diminish the integrity of the property's location, design, setting, materials, workmanship, feeling, or association. Visit the link listed on this slide to learn more about the 7 integrity standards. Consulting parties and the public have an important role in this stage of the process because they may be the most knowledgeable about the affected properties. Consulting parties also have a legal right to object to a federal agency's assessment of adverse effects. A formal objection must be considered. In Step 4 of the Section 106 process, the parties provide alternatives to resolve an undertaking's adverse effects. Through consultation, the federal agency will develop alternatives to avoid, minimize, or mitigate adverse effects. Avoidance requires the most substantive change to the undertaking, while mitigation requires the least. If all goes well, the parties enter into a binding, quote, memorandum of agreement, unquote. The real goal of a Section 106 review is to achieve true consultation and reach consensus. Because Pullman is a National Historic Landmark District, it enjoys two even more stringent protections under federal law. First, federal law requires that the head of the responsible federal agency shall, to the maximum extent possible, undertake such planning and actions as may be necessary to minimize harm to the landmark. As both a national monument and a national historic landmark, it would seem obvious to us that Pullman's historic resources are to be protected and preserved in perpetuity. Second, when an undertaking affects a National Historic Landmark, the Secretary of the Interior must be notified. The National Park Service is authorized to act on behalf of the Secretary during the Section 106 review. Therefore, the National Park Service must serve as a consulting party for the Section 106 review of the Pullman Artspace Lofts and should represent the interest of the American people. Visit Pullman106.com for more information and updates. To request consulting party status, send a letter or email to the Department of Fleet and Facility Management. If you don't wish to serve as a consulting party, but still want to make 2FM aware of any comments you have regarding the area of potential effect, historic resources in the project area, or potential adverse effects, you can send a letter or an email with this information. Lastly, be sure to tell your friends, neighbors, and the public about this important review. The more people who know about the review and are engaged in the process, the more likely it is that the process will be lawfully conducted.
This place has been a milestone in our journey toward a more perfect union.